Dear European Commission, we were tasked with the assignment to research and give a policy recommendation on whether liability for traffic accidents should be regulated at a national level or at the European level. Here are the findings of our research.
Regulation at the European level would be desirable for various reasons, most connected to issues that arise in the end of cross-border accidents. First of all, the differences between our legal systems regarding road traffic liability are an obstacle for the internal market. This is evident in the case of pan-European forwarding companies, which operate mainly with trucks and have to cross different countries. This means that they have to inform themselves about different liability regimes, which costs money and time and puts them in a disadvantaged position against competitors which operate in only one country. Moreover, in the event of cross-border accidents, there are many ways in which victims may be put in a more disadvantaged position than they would be in their home country. In fact, the different liability regimes create legal uncertainty for travelers. For example, not all the member states allow for the same types of damages. In fact, a separate claim for damages for pain and suffering exists for indirect victims in case of fatal traffic accidents in Austria and France, but not in Germany or in the Netherlands, for example. Ordinary citizens don't have knowledge about the 28 different road traffic liability regimes in the European Union, so it is impossible for them to know what types of damages they can claim and how liability attribution works in the different countries. Most likely the victim would have to hire a lawyer from that particular country in which the accident occurred, which is costly and complicated due to language barriers and so on.